You're a first felony offender. Your offense is indecent behavior with a juvenile. You pleaded to that charge. The original charge was 2 cases of first-degree rape. Is that correct?
Yes, sir, that is correct.
You were sentenced on January 24th, 2018. You received a 9-year sentence at hard labor. Your parole date is March 16th, 2021. You're not eligible for good time, and your full term date is March 18th, 2027. Are those dates correct?
Yes, sir, to my knowledge, they are.
Okay. And let me get to your case. We have some feedback. Would everybody except Bozier and myself mute their mics, please? Okay, Mr. Castaneda, you are 30 years old, is that correct?
Yes, sir, I'm 30 years old.
And with time, for time served, you served 3 years of a 9-year sentence, is that correct?
Yes, sir.
Tell me about your disciplinary conduct in the 3 years of incarceration. Have you had any disciplinary write-ups?
I had one disciplinary write-up about 2 years ago, sir. That is the only one I've had.
Okay, and that was in 2019?
Yes, sir.
And what was that for?
I didn't take my medicine. I was trying to get off my medicine and I didn't take it and I put it in a cup. And instead of going through the proper procedure to get off my medicine, and I got caught with 2 pills.
So it was for contraband?
Yes, at that point, yes, it was contraband.
Okay. So tell me about the programs you've completed in 3 years of incarceration.
I am in the SL program, sir. I've completed phase 1. I have also completed the drug program. I've done, I graduate February 26th of this month. I've learned a lot from them. They've opened my mind. They made me see where I was wrong, what I've been doing wrong, what I need to do right. And if I put it into practice, it's a good thing to follow.
So you're in the Steve Hall program for substance abuse with a concentration in sex offender treatment, is that correct?
Yes, sir, that is correct.
And you've only finished phase 1 of the sex offender part of it?
Yes, sir, that is the only phase that I've completed because of COVID. I had COVID early last year, and there was there was some cases in here, so the class got backed up.
Okay, and Bozier's staff, how many phases to that sex offender treatment is there?
They do 4. He just started on phase 2. Like you said, we weren't able to have the face-to-face class month to test. But he's been studying the books in the dorms. But he's only.
So basically, he has 3 more phases to complete.
We usually get through phase 2 in the program, and they oftentimes finish later. But
okay. Okay. So his completion date is February 26th of this year. Is that correct?
Yes, sir.
Okay. Thank you. Have you taken any other programs like anger management, victim awareness, parenting, partners in parenting?
I've taken victim awareness, anger management. I'm also on the AA and NA class. I'm not allowed to take the parenting class because of my charge.
Okay. Tell me about your vocational skills. Do you have anything, culinary arts, carpentry, anything in vocational?
I have an associate degree in IT, communications, and computer science.
Okay, so you're a computer scientist.
I do IT, yes, sir.
Okay. Did you have a full-time job at the time of your incarceration?
Yes, sir. I was an active military member.
You're what?
I was an active military member.
So you were still in the military at this time?
Yes, sir. I was in the military before my arrest.
Okay, were you discharged because of your incarceration?
That is correct.
And it was dishonorable?
No, sir. It was under general conditions.
It was under general conditions. Were you ever convicted of the charges that you received while in the military?
I'm sorry, sir. Can you repeat the question?
Were you ever convicted for charges that you received while in the military?
No, sir.
Are you arrested for theft of U.S. government property? Is that correct?
I was arrested, yes.
And what was the disposition?
Charges were dropped, sir.
Okay. And you had some sexual assault charges also when you were in the military. Is that correct?
That is correct, sir. I had one count of sexual assault against me.
And what was the disposition on that one?
It went through trial, sir, and I was found not guilty.
Okay, very good. Tell me about your transition plan. Where do you plan to live and where do you plan to work?
My parents were able to find me a job with Innovich. It's a company that takes care of elderly people. I'll be taking care of my father. I'll be getting paid for it. They are helping me if granted parole. They have found me an address through a family friend as well. It would be in Pueblo, Colorado. That's where they reside.
Have you started working on your interstate compact?
Yes, sir. I've already submitted all the paperwork to DOC.
Thank you, sir. Would the staff have any comments, observations, or remarks?
No, sir.
Thank you. Now I'm gonna read some things, Mr. Castaneda, and if you agree with anything that I say, stop and correct me, okay?
Yes, sir.
From my observation, Mr. Castaneda, you have a history of sex charges. I didn't say conviction, but you have a history of sex charges. You have a domestic abuse battery charge in 209. You have a cruelty to juveniles in 210. Theft of United States property in 210. You said that was dropped. And the sexual assault charges, which we were found not guilty. You have opposition from the sentencing judge. You have opposition from the DA's office, the sheriff's office, and the chief of police in Shreveport, Louisiana. Your brother is voiced his opposition to your release. The children could not be located because they're in state custody in foster care. Both victims are still emotionally and mentally affected by your offense. And basically, is it any of that information not true?
You're correct, sir.
That concludes my interview. Mr. Marabella, do you have any questions?
I have a couple of questions. Mr. Castaneda, I've read your file. Do you have any explanation as to why you did what you did?
There's no excuse, sir, for what I did. I take full responsibility for my actions. Anything that I can say or that I can come out with would just be an excuse.
Have you ever had any sort of mental health treatment?
Yes, I have.
What kind?
I went through PTSD and depression through,
When was that?
this was in 2016 and 2017. Late 2016, early 2017. I did inpatient and outpatient.
Do you have any idea what effect this has had on the children in this case?
It's been detrimental to them. It's been beyond anything that I can explain in words. I know they are devastated. I can know that they've been through a lot in the last few years of their life, and it's got to be a tremendous just a big detriment to their lives, especially coming from their father, somebody that's supposed to take care of them and not hurt them or do anything that's wrong to them. And I know this is going to have a big impact on the rest of their lives, no matter what therapy they get or what they go through. This is going to be something that's going to affect them for life, and that is on me 100%.
That's all the questions I have. Thank you, Mr. Rusher.
Thank you, Mrs. Marabella. Mrs. Wise.
I have no questions.
Mr. Castaneda?
Yes, sir.
Castaneda, do you want to make a final statement?
Yes, sir, I would like to. First of all, thank you for this opportunity. And I would like my children to know that I am truly sorry for my actions, that I wish I could take it all back. And that I hope that they know that this is not a reflection of them. This is 100% on me. And I also want to say sorry for the people that were indirectly affected by my actions. And that if given an opportunity for parole, I will do what's right and do anything that I can possibly do to to pay reparations or anything that I can do to better the situation for what I've done. That is it, sir.
Thank you, Mr. Castaneda. Mr. Castaneda, based upon very strong victim opposition, prior history of sex charges, incomplete sex offender treatment, law enforcement opposition to the DA's office, opposition from the sentencing judge. My vote is to deny your request based on the reasons stated. Mr. Marabella.
Thank you, Mr. Chairman. My vote would be the same for all of the same reasons.
Mrs. Wise.
My vote is the same for the same reasons.
Sir, your request for early release has been denied. You have received 3 votes to deny your request. You have a good day.
Thank you, sir. You too.
You can't make this up. You simply cannot. This disgusting excuse of a human being has literally been making a mockery of the entire establishment of this system of society his entire life. In what world does a DA make a deal with you where you get 9 years? A 9-year sentence for doing this to your own children? Are you kidding me? Why? This is the only article Richard was able to find. But we're going to unpack this. He's suspected of sexual assault of 2 youths multiple times. This is what it says here. Maximum security facility booking record shows he was booked and locked up 7:14 a.m. Wednesday after being transferred. in charges with 2 accounts of first-degree sexual assault. They arrested him after investigating a complaint that he engaged in sex acts with youths, both under the age of 13, multiple times over the past several years. And this article, of course, has it wrong because it was his children. Now, do you know what the actual legislation is for doing that to your children at this time? He was facing more than 40 years. Now, this legislation is absolutely crazy, right? You should get not less than 5, but no more than 40. But you only need to serve 2 years before you can get parole. That's the legislation. Now, this was also an incest charge, which meant that the minimum would have been 25 years. But forget about it, right? I mean, what do they care? Instead, they give him a plea deal of 9 years. Why? You can't make it up. And then when you find out that he was accused and tried for sexual assault while in the military. He was accused and tried for theft while in the military, and somehow he got out of it. And then when the military hears about this charge to his own children, they don't even do a dishonorable discharge, even though he pleads guilty. No, instead they give him a general discharge. Are you kidding me? Why? You go through his track record and it consists of battery, it consists of cruelty to a juvenile. Those are the ones that has officially on his record. Then he found not guilty of sexual assault in the military, not guilty of theft, and then he pleads guilty to these cases. And he still gets a general discharge? Are you kidding me? Who is it that's making these decisions? Why? How do you sleep at night? You know, it's very rare that a judge makes a statement on these cases. The judge was opposed. Well, judge, you're a big talker, because why in the world would you give 9 years to someone who has a record like that? Forget the record like that. The fact that he was doing this to his own children, are you kidding me? How does someone judge in these situations? And it's like, oh, well, they didn't want to put them on the stand. And I just recorded right before this a hearing, maybe you've seen it, where a man was doing this to his daughter under the age of 12. And she took the stand against him. And a jury found him guilty. And you know what the judge gave? 15 years. That was it. After putting the state through all the cost and the jury and finding him guilty and putting her on the stand, the little girl on the stand, and all the judge gave us 15 years because they're a bunch of jokes. I know there are some good judges, but very few. And then to top it off, as if we need to add more insult to injury, as if we have to cause more fear and doubt in the system, we find out that what he's learned while in prison is to be an IT guy, to work on computers. I mean, did I hear that wrong? Was that a skill set he had before he went to prison? Or is that really the skill that they taught this scary, scary lizard humanoid thing? And then on top of it, he's going to get certified to take care of elderly people when he gets out. That's his plan, starting with his father. And then where do you think that's going to go next? Who do you think he's going to be helping us once he has his foot in the door, taking care of elderly. And all he's done is gotten away with it. Gotten away with it. He'll be able to show his what is it, the DTW or whatever. He'll be able to actually show a DD form from the military saying a general discharge. It's sick. It's really sick. People should be investigated for these type of things. You can't, just think about the victim in military who he sexually assaulted. I know he was found not guilty by a military courts, and we all know about all the problems there, right? That poor woman. And the military still gives him a general discharge. Well, this is part of why we do this, because if you didn't see it, you might not believe it. Our system is broken. It's destroyed. I'm happy to say he's still locked up, right? But he'll be getting out soon. We might even see him sometime soon. And when we do, we'll play it here. Thank you, Richard, for the info. With that, I'll let you go.
On or about 12/25/2019, you were arrested by St. Tammany Parish Sheriff's Office for domestic abuse, battery, strangulation, felony. You were served with NOPH and elected to defer. On or about 7/1/2021, Judge Swartz and the court found you guilty of domestic abuse, battery, misdemeanor, and sentenced you to serve 6 months in parish jail. How do you plead?
Not guilty with a statement.
Not guilty with a statement. And counsel, would you like to make a statement at the end, at the beginning? Would you like to kind of wrap it up towards the end, or if you have something you want to interject, let us know.
Okay, yeah, I would like to make a statement, and I know Mr. Bridges is going to make a statement briefly after me, but it's at y'all's convenience on when.
Go ahead. You can go ahead and make a statement now.
Okay, well, just as a preliminary thing, there was a preliminary hearing transcript, and I believe a 911 call that was submitted at the hearing by the hearing officer that was submitted to them. I hope that's in the record. I'm happy to send that along as well. Just a couple quick points. I'll try to be as brief as I can.
Please.
And most importantly, this is the one and only allegation against Mr. Bridges. He was otherwise completely compliant with his parole, working, paying his fees, meeting all his other conditions. Today, he'll been incarcerated for 22 months. So although he got a 6 months jail sentence, he has had this hold on him, and he has had a substantial amount of time as a result of this violation. As y'all are aware, the charges are marijuana third and attempted failure to possess documentation. I just think that's noteworthy for the record. In the case in chief and what was presented at the trial, Mr. Bridges, this occurred on Christmas after Mr. Bridges, after Tiara Show was driving with Mr. Bridges' children in the car. I'd like to play a brief clip from this 911 call. And just to be upfront about it, Mr. Bridges has always maintained that this is an issue of protecting his children from being in a car with someone who was driving drunk. At the time, Ms. Show was on probation for a DWI as well. The officer was mainly focused on the incident that occurred between the two of them. But just real briefly, there's going to be two clips. They're probably 30 seconds at most. I'm going to state what they say in case y'all can't hear them.
I don't look. We already look. I don't know if you've been drinking, but I have been drinking. But I'm not drunk.
And just to repeat that, it says, I don't know if he's been drinking, but I have been drinking, but I'm not drunk. And then at 3 minutes, again, just a few second clip.
Hey, I'm just right at the corner. I didn't go far. Like I said, I'm not drunk, but I have been drinking Christmas, you know.
And again, that's where she actually admits to driving. And the children are in the car to avoid the profanity. There's another clip at 3:55 that says, "You better not take my blank kids." But at that point, 3 minutes, it says, "I'm just right at the corner. I didn't go far. Like I said, I'm not drunk, but I have been drinking. It's Christmas, you know." And lastly, I just wanted to give a few comments about what our hope for, what we're asking for from the board. Mr. Bridges has a strong support system, grandmother, mother, father. Some of them are present. A few of them were present at the trial. Mr. Bridges has discussed any contact with his children being done directly at a police station so that there's no incidents in the future. And he would like to elect, you know, if the board would allow for him to take the Duluth model classes and continue on parole. And Mr. Bridges, I'll leave it to you. I know you wanted to make a statement as well.
All right, thank you. Go ahead, Mr. Bridges. Make your statement.
Okay, Mr. Kelsey, I want to first start off by taking full responsibilities for my actions that night. That night, Tiara was intoxicated, and I was trying to pull out the car so she wouldn't take off with the kids and drive around with the kids because she was delusional. I noticed my wrongdoing once we went to the trial. Basically, the judge told me that even though she was intoxicated, I had no right to touch her, to actually try to grab her and pull out the car. And I admit to my wrongdoings. I should have just left her in the car. I shouldn't have tried to pull out the car. The judge asked me why didn't I call the police, and I responded to the judge by telling him I didn't call the police because I was trying for her not to go to jail. That's why I was trying to get out the car so she wouldn't catch the DUI. But as a deterrent, so this won't happen anymore, we have a talk to talk parent app, so me and her could communicate on a talk to talk parent app, and the child support system is gone for us through the child support system, so I could take care of my kids through that through a mediator. I contacted the courts. The courts told me that I can't have a mediator until I actually get out and correspond with them to put the mediator in place for me and her to go through the mediator. So I would ask if y'all just give me a reprimand and reinstate my parole. I will go out there, get the mediator and put things in place so that this won't never occur again. As I was out there, I was in a community college. I was going to school. I was doing welding, plumbing, and pipe fitting. I had my life on the right path. I was doing what I was supposed to do. My baby mama was very, very angry with me because I didn't come home and be back in a relationship with her. I chose to move on and have another family with another woman. So ultimately, she couldn't handle that. And that's what stirred up the big confusion and the animosity between us. Mr. Roach, Mr. Kelsey, and Mr. Pooch, I could guarantee y'all if y'all release me and y'all let me out and y'all let me continue on with my parole for this marijuana case that I'm on, I will do what I need to do as a father and as a citizen to my community. Thank y'all for your time.
All right, would you answer Mr. Roche's question, please?
Thank you, Mr. Chairman. Mr. Bridges, good morning.
Good morning, Mr. Roach.
Mr. Bridges, I feel as though, as you've explained everything, your attorney has played the tape. I've listened to the tape prior to that, and I've read all the proceedings of the preliminary hearing. I think there's something that we're not hearing this morning. I understand that you had a bench trial, am I correct?
Yes, sir.
And Judge Forks found you guilty
Yes, sir.
of misdemeanor, of a misdemeanor domestic abuse battery.
Yes, sir.
And you are aware, because you are familiar with the system, that a violent misdemeanor is a revocable offense.
Yes, sir, I do.
So basically, tell me what else transpired that the judge, in his wisdom, found you guilty.
Well, we're corresponding with the judge told me that since Tierra, even though they can hear that she was under the influence, made the allegations that that basically she was a witness to the case and that I was guilty of the charges because I had no right to actually put my hands on and grab her out the car. He was like,
Especially put your hands around her neck.
we're putting my hands around her neck. They found that to be not true. That's why they dropped the charge down to a misdemeanor, because they found out during the trial what actually transpired, Mr. Roach.
Okay. But still in all, the judge, in his wisdom, found that you in violation of breaking the law, which is a violation of your condition number 4 of your parole supervision contract. Am I correct?
Yes, sir. You're correct, sir.
Thank you.
All right, now we'll hear from Miss Brenda.
Good morning.
Good morning.
My name is Brenda Holloway. I'm Dwight's grandmother. And I'm going to speak on his character. And Dwight is a very good child. He loved his children. He was out here doing everything that he needed to do to take care of his kids, to work, to be a part of their lives, to be back in the family, to be with us. He was doing everything that was right, everything that was right. And we tried to still include Tierra within the family because they're still our grandchildren. But every time we have her in the midst of the family, something always conspires. And it started with me that night, and when she asked to speak with me. And we went outside, we had some words. She tried to talk to me. She tried to apologize to me for the incident that had happened at my house when my mother was dying. And that's what spurred the incident that night, okay? And it went into a big old thing because she had been drinking. And so it escalated to the end of the night. So since then, we have dismissed ourselves from Tierra because every time we try to have her with family, when we having holidays and stuff, it always ends up bad. So now we have dismissed ourselves from her so she can no longer come in and disturb what we have going on. And everything was beautiful that day until she started drinking, and she took me outside and she got me really upset and everything as I was trying to leave to go home. And that's what sparked that. Other than that never would have happened because he was on track doing everything.
Okay, thank you. Now, as I see, is Mr. Milton there? Does he want to say something?
Yes.
Yes, good morning to everyone. I must admit, this has been a very challenging time. A night full of a lot of regrets. I've always regretted inviting her over, but by tradition, we've always had all of the children parents for the holidays when we're doing things like that. My biggest concern is, and I can't say it enough, Dwight was doing everything right. I saw a young man that was keeping his word to what he promised me, that he wasn't gonna go back. I mean, I saw him fulfilling a trade, preparing to have his own house and a place to have a roof over his kids, head. He was doing things right. And for one night, that almost at the stroke of midnight, for it all to be stripped away because of a decision I made to allow her to be here and to indulge in the amount of alcohol that she did, I regret it because it has stained his life. Had she not been drinking, this probably never would have went down. He wasn't here. So at the time when all of the drinking was going on, because he was by one of his other children.
You was picking them up.
Yeah, picking them up to bring them here to wake up Christmas morning with their father. And I would just ask for the parole board and the officers of the court to please allow him this chance to fulfill the promise he made of being there and being a father to his kids and preparing them to be productive in life, as I was continuing to see him actually fulfill this time.
All right, thank you. Now we'll hear from Ms. Jade.
Hi, how you doing? I'm Dwight. My name is Jay Johnson. I'm the mother of Dwight Bridges' youngest child. I do understand that all actions have consequences, and he is not a malicious person. He did make a mistake, and he has almost sat down for 2 years to think about that mistake. I ask that you take in consideration, I'm a full-time nurse here in St. Tammany, a med-surg nurse. And prior to us or his incarceration, I found out I was pregnant. He has a child that he has yet to meet that is 14 months old. I have worked all the way through a pandemic alone. I've worked through a pandemic alone with COVID. I went through birth alone because of COVID. And I'm speaking on behalf of my child who has yet to meet him in person. And not just my child, but his other children who need him, not just financially, but emotionally. Prior to this, he was working and doing what he was supposed to do. And I know that with his family and my support, we can guide him, on a better direction. But first and foremost, he has to make those choices for himself also. I just ask that you consider letting him out, not just for himself, but his children.
All right, thank you. All right, thank you. All right, Mr. Bridges. So the lady in question, are you still with that lady in question at all? You're still seeing her? How many kids do you have?
Well, I have 7 kids total. Me and Tiara Shobi, the one who the incident was done by, we have 3 kids together.
So you need to be working. You got 7 kids, boy, I'll tell you. So you're not currently seeing, does she live? You're not currently with her? Is that what you're saying?
No, I'm not with her. I'm with Jay Johnson. We started a family and our youngest child, and we was moving about on with our life. Me and Tiara Shobi, we was co-parenting with our 3 kids that we had.
Okay.
Mr. Kelsey, just to add on, because I was present at the trial, Judge Swartz extended a protective order as to the children subject to the jurisdiction of the family court, with the idea that when he gets out, he will be able to move through the family court system before any contact is made with either Ms. Shobe or the children. Her children, not all of his children.
Okay. All right, thank you. All right, would you like to wrap it up, make one more statement, and be done there, Mr. Bridges? Or you said what you need to say?
Yes, I will gradually appreciate the court. I would surely appreciate the parole board if y'all will reinstate my parole today. Mr. Roach, I understand your concerns, Mr. Roach, and you wouldn't be disappointed, man, if you voted in my favor and let me go today. I am gonna do what I need to do because I know what I need to do. This marijuana charge for this gram of marijuana, Mr. Roach, has cost me a lot. I've been in here 10 years, 9 years, going on 10 years currently on that charge. And it's really depleted my life, man. Every time I get up and I get back acclimated and get on a great path, something makes me, I stumble in a certain direction. But this time I gave everything up. I did what I needed to do, and I'm gonna continue on doing that, Mr. Roach. And I hope that Mr. Roach, Mr. Marbella, and Mr. Pooch, y'all grant me parole, y'all reinstate my parole with a reprimand, and I'll take classes, anger management classes, or whatever I need to do to continue on with my success.
All right.
Mr. Kelsey,
Yes, ma'am. Yes, sir.
I'd like to make a motion for an executive session.
Got a motion for executive session. Do we have a second? Got a second. Roll call, please.
Mr. Kelsey,
Yes.
Mr. Marabella,
Yes.
Mr. Roche.
Yes.
We'll be right back.
All right, it was like a 3-minute wait, so we're just gonna skip it and jump back into the hearing. But what do you think they're gonna do? Before we jump back in, we have seen maybe 1,000 hearings, and I don't think we have ever seen anyone call Mr. Roach. It was, it is what it is. But okay, anyways, with that, let's jump in.
All right, Mr. Bridges, we're back in order. The panel's prepared to vote. I'll go ahead and vote. I've listened to everything that your attorney said, listened to your story, and listened to Ms. Johnson and your family. Listen, you can't put yourself in those situations. You have to walk a tight line. You understand that when you're on parole, you cannot, this is all part of the growing up and being an adult, part of the parole. You can't let, your anger overcome you. You have to, think. I mean, you're going to be presented with tough situations again, okay? And you've got to be able to maintain and do right. It's not you spend a lot of time to do. Listen, I personally, it's just me speaking. I believe your story. I can't speak for my colleagues, but I believe your story. But you still can't do that, right? You have 7 children, and you are responsible for all 7 of those children, okay? My vote today would be to do not revoke your parole, but I would require you to go to a 26-week domestic violence prevention program. It's a DBOP, domestic violence, and your attorney can get you set up with that. Mr. Moore, you can make sure that he gets that taken care of. You have to enroll it and complete it. Okay, do you understand?
Yes, sir.
And then you would be back on supervision. You continue the same stipulation that you had before. That's my vote today, and I wish you good luck. Mr. Roche?
Thank you, Mr. Chairman. Mr. Bridges. I believe you stood, but I think the thing that convinced me most of all was your grandmother and the young lady that spoke after the gentleman. And is that gentleman a member of your family?
Yes, that's my dad.
So that your dad. Yeah, I should have known that. He spoke as if he was your dad. And he was very sincere. And in his effort to have all the family together so that his grandchildren could have their mother at a Christmas gathering, he made a little mistake and didn't realize the repercussions of having someone that was not there in good faith.
Yeah.
So I'm going to agree with Mr. Kelsey. And I think your grandmother and your father had a lot to do with that. And I'm going to make one other condition. If you don't complete this 26-week domestic battery abuse program, you will be automatically revoked.
Okay. All right.
Good luck, sir. Good luck,
Mr.
sir.
Marabella.
Mr. Bridges, I, like my colleagues, are very concerned about the crime that you have been found guilty of, domestic abuse battery. I understand what you're saying and why you did what you did, but you can't take the law into your own hands.
Right.
It sounds like you were trying to protect this woman as well. You didn't want her to go to jail. You wanted to help your children. But those are the kind of decisions that this domestic violence program will help you make in the future. I agree with Mr. Roche. This is a critical condition of your parole. So you need to immediately enroll in that program and complete that program. Okay? Hopefully you will learn some things. You've got some great support. I'm going to be real honest with you. Like Mr. Roche said, coming into this thing, I was likely going to revoke you, but you got good family support. You've done some good things. You've been in jail for 22 months. That's a long time.
Yeah.
Hopefully you've learned some things. And you've got a lot of children that you need to give a good example to. So my vote likewise is going to be not to revoke, but add as a condition that you complete the 26-week DVOP program and you enroll immediately and you complete that program. You get kicked out, you drop out, whatever, you're going back to jail. You understand?
Yes, sir.
Good luck to you.
All right, you have 3 votes. Do not revoke. You have to complete 26 DVOP program, enter and complete. 3 votes that do not revoke. Good luck to you.
Thank you, sir.
Thank you, guys.
Thank the board.
Thank you all.
Man, so yeah, that was for me. That was certainly an interesting revocation hearing. I can't recall how many times we have seen an attorney start off with their statement versus finish with their statement, but I think that was absolutely the right move in this case. He set the table for the entire parole revocation board to hear what seems to have likely gone down that night. And I thought that was one of the better attorney handling of a revocation case that we've seen. I don't think we've seen him before either. I mean, you can tell he put in the time, right? He actually went out and was able to get access to that part of the phone call where she called 911, where she stated that she was the one drinking. We've just never seen that before. So bravo to him doing his job. And it just can't be taken for granted. We have seen, I think, probably more often than not, where there might be an attorney representing a client in a revocation hearing, and they come in and they just look totally lost. They seem to not know anything about the case, not be familiar with the procedure of revocation hearings, not to put their foot in their mouth, to even at times insult the parole board's intelligence, in my opinion. But he came out there and he did a great job. So I would say money very well spent, because it could have easily gone the wrong way. And then to think, I think of the tragicness of this case. And as Mr. O'Shea said, I thought his father spoke really well, in the sense of it seemed that they were trying to have a beautiful Christmas, and the tragedy in it. And you got to feel for those poor kids. is they have she drank too much. He gets the kids in the car. He, of course, does something he should never do. The judge found him guilty, so obviously it was bad. But again, going kudos to the attorney and the family, that almost makes you forget that part. And then he ends up locked up, and that's a Christmas memory that you'll never be able to erase from those poor kids. And they blame it on the booze, right? But I really do want to root for him. Unfortunately, Richard shared some information that makes it a little bit more difficult. I mean, he has they didn't talk about it here, but I guess he's a tier 1 sex offender. The offense goes back to 2004, and it's sexual battery. And he's a tier 1, so it's probably a misdemeanor. It's not clear, but again, we have no idea what it was for. And then this is the initial crime that he was sentenced for, what he's on revocation for, so we can go through that if you're curious. So the facts are, let's see what his appeal is. He was charged with possession of Mary Jane, third offense. So classic Louisiana, right? Possession of the devil's lettuce, not possession with the intent to distribute, just possession. He pled not guilty, and following a jury trial, he was found guilty as charged. I really wish he didn't have that sex offender charge on him, because this would be kind of like the classic case. He was sentenced to 15 years. 15 years. Let's just forget everything. He was sentenced to 15 years for possession, not intended to distribute. And we talk about this all the time. We talk about how broken the system is, that you would get 15 years for a third offense, possession. And we see over and over and over again where people can harm their children and get less. On January 5th, 2013, 9:30 p.m., the sheriff's office deputy of Stone was traveling westbound with his partner, Deputy Mike Rapole, who he was training. Deputy Stone observed the blue vehicle traveling eastbound at a high rate of speed. Using his radar, he clocked the vehicle's speed at 63 miles per hour. Because the posted speed limit was 45 miles per hour, the Deputy Stone turned his vehicle around and conducted a traffic stop. 63 and 45 is not like, depending on the car you're driving, you can go 63 and a 45 without even realizing it. You can do that in a nice minivan. So, but the cop pulled him over. Both deputies approached the vehicle while Deputy Rapole approached the driver's side where the window was rolled down, and Deputy Stone approached the passenger side where the window was up. Deputy Stone could smell the odor of Mary J. He asked the driver, later identified as the defendant, to exit. When Deputy Stone requested permission to search the vehicle, the defendant declined. So the deputy called the K-9 unit to the scene. While the deputies waited, the K-9 unit arrived. He conducted a pat-down search of the defendant as well as field. Oh, here, look. See, they got him as the habitual offender here. That's why I got the 15 years in habitual offender. Defendant's predicate offense, October 12th of 2004 for sexual battery. They have that there, you see. Now, sobriety test. Deputy Rapole did not locate any weapons or illegal contraband on the defendant, and defendant passed the sobriety tests. St. Tammany Parish Sheriff's Office Deputy Ronald Oliver arrived at the scene shortly thereafter and conducted a search with his canine. Thor. That's a great name for a canine unit. Thor. Thor gave a narcotic odor response as soon as he approached the roll-down driver's window. Deputy Oliver unleashed Thor, and allowed him to enter the vehicle. And Thor, that's just such a great name, indicated that he detected narcotics in the passenger glove compartment, which was open. Deputy Oliver searched the glove compartment and located a balled up piece of paper containing suspect marijuana. And here's something, I don't know if you guys have, I have seen different takes on this, and you know, I don't know. I'm sure there's okay, where they say that canine units are oftentimes told when to notify the handler, and that it can be triggered, and you know, it wouldn't it just wouldn't surprise me at all if that was done a lot more than we thought. And it's like, you know, I'm sure there were narcotics in the car, but it's like also if you have a dog and you suspect that there's narcotics, and you can tell your dog, hey Thor, you know, make a say that, you know, oh yeah, there's something in the glove compartment. I mean, you get what I'm saying? It's like, of course you're gonna want to check the glove compartment. So of course you're gonna say that your dog Thor said, hey boss, there's stuff in there. And that's where I think there's a lot of sketchiness that probably goes on with canine units. I'm just saying that it probably exists, and whatever you want to do with that, do with it. But anyways, they did. That's not what where the idea that he would get 15 years for this is insane. So they located a balled up piece of paper containing suspected marijuana. He also located a blunt. And after search, Deputy Oliver gave Deputy Stone the items he recovered. Content both tested positive for marijuana. That is just so twisted. I'm telling you, it's twisted. So they get him on the speeding. They don't find any contraband on him. He passed the sobriety test. They do the right thing by saying, you can't search my car. That's the right thing to do. They bring a canine unit who then detects something in the glove compartment, and they seem to find some negligent amount of marijuana, and he gets 15 years. That makes me sick. It does. It's just the system. It's a broken system, man. It's a broken system. It's insane. It's insane. What's part of the appeal here? Assignment of error. In his first assignment of error, the defender contends that the state exercised challenges to the jurors based on race in violation. So they're saying basically in the selection process, they use race to select the jurors. Specifically, he objects to the state challenges of 3 black female potential jurors. The Supreme Court held an equal protection violation occurs if parties exercise a preemptory challenge to exclude prospective jurors or the basis of the person's race. If a defendant makes a prima facie showing that the discriminatory strikes the burden and shift to the state racially neutral explanation. So basically, they're stating that, and the state is, of course, going to say, no, that's not the case. Then they say, what else did they say? After jury 6 was selected, the state exercised a backstrike on previous elected juror Alice Cousin during the stated that she was a retired teacher's aide, a widow, and that she had 2 adult children. She previously served on a juror for a sexual assault trial that resulted in a guilty verdict. After the state exercised the backstrike, defendant objected, according to the state, cut 2 of the 3 potential jurors. The court asked the state to demonstrate I don't know. They're going through. So what did they end up finding? Accordingly, we find no abuse and discretion of the district court, denial defendant. Okay. Now, assignment of error number 2. In this second assignment of error, the defendant argues that the district court violated his right to present a defense at trial. Defendant requested that the jury be allowed to view the defendant's vehicle and stand next to it with the passenger side window rolled up and the marijuana located at the same place. It was on the night of the incident inside his glove compartment. Defendant argues that the district court's denial of his request violated his right to present defense because this was the only direct, dramatic, and definitive proof that he had that the testimony given by St. Tammany Parish Deputies called the state witness was incredible. Defendant contends that contrary to his testimony, Deputy Stone could not have smelled the odor of marijuana from outside the passenger side of the vehicle with the window rolled up. At trial, he argued that he was attempting to impeach the testimony of Deputy Stone with his request. The state objected to the defendant's request, arguing that opening the driver's side car window in a parking lot would not accurately depict the scene on the highway on the night of the incident. The state noted that the marijuana was, at the time of the trial, 8 months old and had been opened and analyzed at the time of the trial. The state also pointed out that there was not a way to ensure the vehicle was in the same condition. So basically, they were saying is that they wanted to put that piece of marijuana in the car, open up the window, and I guess see basically if the jury could smell it, which they would not have been able to smell it. It looks like the judge ruled that wasn't allowed because they're saying that things have changed. The car is in different condition. The marijuana is older. Be unable to recreate the conditions that existed in which 3 officers testified. The district court agreed that a significant amount of time had passed from the date of the incident trial and how the vehicle was handled. I hear why you would exclude it because, I mean, if they were smoking in the car right before it happened, you would smell it. But at the same time, they had no proof that they were doing that. They didn't find any paraphernalia or exist. So I could see it both ways. District court, accordingly, we do not find any denials of the defendant's rights to present a defense. So they give all the reasons as to why he's not allowed to do that. Okay. In his third assignment of error, the defendant argues that the district court erred by allowing the state to elicit testimony related to the defendant's invocation of his Fourth Amendment rights. Specifically, defendant argues that the state questioned Deputy Rapole regarding defendant's refusal to consent to a search of his vehicle. Defendant also complains that the state commented on defendant's refusal to consent during its closing argument. You can't do that. You can't comment on that at your closing argument. While Deputy Rapole was being questioned on cross-examination, defense counsel highlighted defendant's cooperation with the officer's request before and during the stop. According to Deputy Rapole's testimony, defendant immediately pulled over when the officers activated the police unit's lights and sirens. He produced his driver's license, registration, and proof of insurance. Defendant exited the vehicle when asked and complied with the request for a field sobriety test. On redirect examination, the state said, "Now, I heard a lot of cooperation by the defendant. He cooperated with this. He cooperated with that. He cooperated with this. Is there anything he failed to cooperate with?" Deputy Rapole responded, when we asked if he could search the vehicle, when Deputy Stone asked if we could search it, defense counsel objected, arguing that commenting on defendant's choice to exercise his right under the Fourth Amendment was improper. In response, the state argued that defense counsel opened the door by eliciting testimony regarding how cooperative the defendant was with the stop. Well, that's true. It did open the door. The state contended that it could show that the defendant was not completely cooperative. Agreeing with the state, the court stated, "But you opened the door with all your other questioning." I agree. They did. The state proceeded to question Deputy Rapole, asking, "As a result of the defendant's failure to let you search his car, what did you and the deputy do to remedy the situation?" Deputy Rapole answered that Deputy Stone requested the assistance of the canine unit. Now, this is interesting to me, so I'm going through all of it. Defense counsel was allowed to recross Deputy Rapole, and the following exchange occurred. Defense: "Deputy, when the prosecutor asked you whether or not the defendant was cooperative and everything, you indicated that he wasn't cooperative. In your opinion, on the request to search his car, is that correct?" Deputy said, "Correct." So defense counsel says, "You regard someone exercising their constitutional right to have a search done legally as non-cooperative?" This is great. I like that. The deputy: "It wasn't a yes answer." Yeah, it wasn't a yes answer. "Yes, ma'am. I didn't. His defense counsel was a woman. Defense counsel. So because he said no, he wanted his constitutional rights. You said that was uncooperative? Deputy. Yes, ma'am. Defendant acknowledges. Yes, ma'am. So defendant acknowledges in his appellate brief that Louisiana jurisprudence does not address prosecutorial questions and comments related to defendant's exercise of his rights to refuse consent, search cited. So, yeah, I mean, are we surprised that a police officer would say that it's non-cooperative if you want to if you want to invoke your constitutional rights? No, we're not surprised. You just watch enough of that Audit the Audit, and you're kind of left with that kind of vibe. And I'm all blue, by the way. I'm not anti-police officer. I'm just, my eyes are wide open, and I'll say it how I see it, okay? In support of his argument, however, the federal jurisprudence appears to hold a reference to defendant refusal to consent may be admissible in the purpose of other than support an inference of guilt. And as I've said many times before, my sister is a police officer. I love police. I support them in their fullest. There are police officers, like every profession, where they need to be called out, and that's what we'll do here. Additionally, at least one court. The bottom line is that he got sentenced to 15 years, and this was the final charge that pushed it. It's just wrong. Like, how can you go to, I know the police officer probably had no idea what this guy was in for, but really, this is what you're worried about in Louisiana? Really? All the money, think about all the money that it costs the taxpayers, this one incident, just from the moment he was pulled over until serving all that time in prison. This was possession of a little bit of marijuana. He's driving with a fully insured, licensed, registered vehicle. There's no, like, come on, man. Unbelievable. It goes on. I won't keep going through all of it. But it is just, to me, it's absurd. We find no abuse of discretion in the court. There's ample justification in the record for a 15-year sentence being imposed on the defendant, and a hearing on the motion to reconsider was not required. Accordingly, the sentence imposed is not grossly disproportionate to the severity of the offense. It's severe. Think about how severe. He has the devil lettuce wrapped in a little tinfoil in the glove compartment of his vehicle. Clowns. Just like that. Boom. Adjudicated. You wouldn't believe it if you didn't see it. And there you have it. And that's why we do this. That, I'll let you go.
The second felony offender with the parole eligibility date of January the 7th of 2003. He's not eligible for good time. His full term date is April the 7th of 2024. He is currently serving a 5-year sentence for terrorizing and aggravated battery. Sentencing date on the terrorizing charge, as well as the aggravated battery, was April the 25th of 2019 and September the 16th of 2019. Is that fairly accurate, sir?
Yes, sir.
Your case has been assigned to Ms. Pearl Wise. Please answer her questions.
Good afternoon.
Afternoon.
How's it going?
Good. About you, ma'am?
It's going good. Thanks for asking. So Stephen, tell us how long you been in jail on this charge?
It's about to make 4 years.
Right, by the way, 4 years. Okay. And you and how old are you today?
24.
24. Stephen, your record it's something else. You were 14 when you first started getting in trouble. Is that right?
Yes, ma'am.
You had like 3 felonies as a juvenile, and you got 2 felonies as an adult. What do you need? What happened to you? What?
I made some mistakes in my past, and as a kid, I've been down, and I have learned, and I'm trying to learn on changing those mistakes and changing for the better. And I do apologize about the past. I know I made mistakes, and I do want to change for the better.
Okay. Now, when we say mistakes, no, mistakes is like, I step on your foot, I didn't mean to step on your foot, I'm sorry. But like the terrorizing, you repeated call, you just kept calling. What was that all about? The terrorizing, Joey.
Well, at the time, I was going through a lot, and I didn't mean for it to go the way it did. I was under the influence of drugs at the time, and I made a mistake.
What drugs were you under the influence of?
I was under the influence of alcohol and methamphetamines.
How many days had you been up?
Probably like 7.
Okay. And so who was in the jail that you were trying to talk to?
An ex-girlfriend of mine, Megan McBride.
So it wasn't the same girl that you got the aggravated battery domestic on?
No,
It
ma'am.
was a different girl.
Yes, ma'am.
Oh, okay, okay. So what have you done about your addiction?
Well, since I've been down, I haven't been able to. It's been hard for me to get in any kind of help being down, but I've been sober for the whole 4 years, and I really don't even care for it anymore. I really want to get out and go to work and really change.
So tell me about that intoxication write-up on February the 26th of 22.
Well, whenever I was in work release, I met some people that I knew from a previous jail, and they gave me something, and I really didn't know what it was at the time until I was smoking with him, and he passed it to me, and before I know it, I was under the influence of drugs, and I really made a mistake. And yes, ma'am.
So was it against the rules to be smoking?
Yes, not cigarettes, but drugs. Yes, ma'am.
Oh, so you were smoking you thought you were smoking a cigarette with somebody?
Yes, ma'am. And I wasn't sure what they gave me at the time until it was too late.
So you knew it wasn't a regular cigarette?
After a time, yes, ma'am. After I hit it, yes, ma'am.
I'm not clear. So did you know it was a regular cigarette, or did you not know it was a regular cigarette?
I didn't know at first that they spiked the cigarette. No, ma'am.
Oh, okay. Okay. Well, do you think you need some kind of treatment? What do you think?
Yes, ma'am. I would really like to reach out and see if I could get some kind of treatment.
Have you written to be sent to Steve Hall? Have you asked him to send you?
Whenever I went to court before these charges, the judge told me he would strongly recommend the Steve Hall program, but they never was able to find me a spot, and they told me I had too much time left to get in.
Okay. Okay. I just encourage you, just keep asking about getting in.
Yes, ma'am.
That's all I had, Jim.
Now let's hear from your supporters, Ms. Jamie Sepulveda. Ms. Jamie, are you there?
Yes, sir.
Okay. You please introduce yourself and tell us what you'd like us to know.
I'm Jamie Sepulveda. I'm Stephen's aunt.
Ma'am, could you pull your, we only can see the top of your eyebrows. There you go. We're getting better.
Okay.
There you go. Thank you.
I'm Jamie Sepulveda. I'm Stephen's aunt. I've known him all his life. He had some issues when he was younger, and I think spending all those years and months locked up, I think it's helped him grow and learn that he needs to be responsible for himself and to get another chance and to get out and work and take care of himself and try to live the best he can. And
thank you.
He's got family that we all love him, and we're all here to support him in whatever he needs.
Thank you, Ms. Jamie. Mr. Stephen Sepulveda, Senior.
Yes, sir.
Okay. Good afternoon, sir. Tell us what you'd like us to know about your son.
Well, I'd like for him to come on home with me because I'm getting up in age too. My health ain't that good, and I think we'll do good together. And I need him around the house with me. I will help him straight and do all I can. Sure, he will find a job and go to work.
Thank you very much, sir. How about Mr. Frankie, his uncle?
Yes, sir. Frankie Clodo, I'm his uncle. I just like to say we're ready for him to come home. And I'm retired. I do part-time work. He can work with me and around the farm. Let's try to get him on the right track.
Thank you very much, sir. We appreciate it. Let's go back to Stephen. Stephen, is there anything you'd like to say? No, the son. I'm sorry, Mr.
Okay.
Stephen.
Yes, sir. I would like to add something.
Okay, go ahead.
I've been down 4 years and I've been away and I have learned a lot and I do want to change. I want to come home and be successful in my community. I want to work. I want to make my family proud of me. I have left, the past alone and I have grown and I want a chance to show that I can be successful in the community and I could grow. And I promise you, this is the last time for me. I will not come back to jail. I will be successful. I'll make a life out of myself and I will change for the better.
Thank you very much, sir.
Yes, sir. Yes, sir. Mr. Salvador, that write-up, when was that write-up for intoxication?
I think it was like maybe a year ago.
Yeah, because one place I saw February the 26th of 22, another place I saw 1/26 of 21. It is 20. The 21. Okay, gotcha. Okay, so it was 21. Okay, it was 21. Okay. I'm very concerned about you. I'm very, very concerned about you. I'm going, my vote, I'm only one vote, is going to grant after you complete the Steve Hoyle program, followed by TWP if time permits. And for me, it's because of your family support. And they see you today and they heard you today. It's up to you. But I'm just one vote.
Thank you, Mr. Wise. Mr. Jackson.
Mr. Salvador, I'm going to concur with my colleague. I don't think you're equipped. You're ready, but you're not equipped to be successful. You need some substance abuse treatment. You recognize that. And so I'm going to concur with my colleague that I will grant condition on your enrollment in Stephen Hoyle and your completion of transitional work release.
Thank you, Ms. Jackson. Mr. Salvador, I agree with my colleagues. Your parole today has been granted conditionally upon your enrolling and completing Steve Hoyle and then getting into the work release program. Okay.
So I need to add some conditions.
Okay.
Random drug screens by PNP and no contact with the victims. No contact with the victims involved in these two cases. That's true. That's true. Yeah. Well, that's true.
No contact with the non-family victim.
Yeah, no contact with the non-family victim.
Mrs. Salvador, we've given you an opportunity. Now you need to get into the program. We'll do everything we can do on this end to get you into that program. Get there, learn some things, and get into the work release program, and you'll be out.
Sure. Thank you, sir. I
All right.
appreciate it.
Good luck to you.
Yes, sir.
We will be adjourned at Richland.
Well, they gave him a chance, but he didn't make much of it. He was revoked almost a year to the date, October 30th, 2023. So about 2 months from the time of this recording. And if he has a parole revocation hearing, we'll probably cover it here. So stay tuned for that. It's possible that he won't. Sometimes he opt out to have a revocation hearing. If he's only has so much left time to serve, they'll just say, you know what, screw it. I'll just start my clock now and get my time over with. Because when you're waiting for a parole revocation hearing, oftentimes the time won't count towards your sentence. You're kind of like in this no man's land. But man, can you imagine being in a situation where you are calling someone in another jail where they don't want your phone calls, but you keep calling, and and to the point where you get charged with terroristic threats? I mean, that's a whole nother level of nutso. It's like, are you kidding me? I mean, you don't even have the excuse at that point of being methed up for a week straight. You're in jail. There's something obviously very wrong with him. As Miss Wise was saying, like, what happened to you? What happened to you? And it's sad to see. It is. But man, when you don't have the ability to just have that type of self-control, when you're, my understanding was stalking a woman who's also serving time in a scenario where you're obviously gonna, I mean, wow. I wonder how often that happens, but I wish I had more information to share. Again, the revocation hearing does take place. We'll post it. But with that, let's move to the next hearing.
And at the end of that process, Mr. Barron, you'll have an opportunity to say whatever you'd like to say to the board before we vote. Do you understand our proceeding?
Yes, sir.
This is the matter of Terry L. Barron III, date of birth. He has a parole eligibility date of June 14th of 2022, an adjusted good time date of November the 16th of 2030, and a full term date of October the 30th of 2040. He is currently serving a 25-year term for 2 counts of forcible rape and unlawful presence, having been sentenced on all 3 of those on March 16th of 2022. Does that sound accurate, Mr. Barron?
No, sir. I got convicted on the first 2 counts in 1991.
That's correct, but you were resentenced after you were revoked.
Okay.
Okay, you were sentenced in 91 initially, but you were revoked and resentenced on March the 16th of 2022.
Yes, sir.
Does that sound right?
Yes, sir.
Okay, your case has been assigned to Ms. Bonnie Jackson. Would you please answer any questions she might have?
All right, Mr. Barron, how old are you?
51.
Okay. You got revoked on March 16th of 2022. How long had you been in jail before your revocation?
Like 6 months.
I'm not going to get into the facts of your forcible rape charge. Quite frankly, I don't want to get into those facts. I'm familiar with what they are. But you were given a 50-year sentence, and it looks like you served about 24 or 25 years before you were paroled. Is that correct?
Yes, ma'am.
And you paroled on March the 9th of 2015. Is that correct?
No, ma'am. I discharged in September 2015.
That's what I said. I thought I said September 9th of 15.
Okay, then that's right. I thought you said March, my bad.
when when I was reading your file, I went through all of your parole officer's notes. And it seems as if for the 7 years since you've been out, you have done well on supervision. The notes indicate that you have maintained employment, that you keep in contact with your parole officer, you're up to date on your fees, you report when required to do so, and apparently you are current with your sex offender registration and notification. Is that correct?
Yes, ma'am.
So, what happened? Why did you go to this football game?
I wanted to see my stepson play football, and I knew it wasn't right. And I mean, I got punished for what I did.
So it was your stepson who was playing football?
Yes, ma'am. That was my stepson.
And you were there with your family?
Yes, ma'am.
How many?
My wife and he's 18 months old now.
And your wife and your 18-month-old, your infant, your wife were there to watch your son play football. Is that correct?
Yes, ma'am.
Okay. And somebody, I think a deputy at the game recognized you, notified your parole officer, and you were arrested and you're here today.
Yes, ma'am.
So what have you learned from this experience, Mr. Barron?
That I can't get away with it. I mean, I did, I tried to do something and it wasn't right and I can't get away with it. I learned that, I've learned to appreciate what I got now more than I have in the past. And I've learned that I just gotta stay focused on my family and don't worry about nobody else and just do what I gotta do.
What kind of work were you doing?
I was a robotic technician.
Who did you work for?
The Groove Paint Body and Nissan of Lake Charles.
How long did you work there?
Since 2018.
Do you know whether or not you still have a job or could get a job back?
Well, not with him because my parole officer said I can't anymore because I think it's around college that the high school go to. So I do have other opportunities if I make it, if I can go home. I do have other opportunities to find employment, which is not going to be hard. I mean, if you do the work, you can get it done.
Have you taken any programs since you've been back in jail? I imagine you haven't had a lot of opportunity to do so, but have you taken any or are you enrolled in any right now?
I tried to get Riverbend to let me do something and they keep telling me no. And because of my charge and I'm a violent crime. And
do you have a job at the prison?
No, ma'am. They say I got sex offense, so I can't have a job here.
Deputy Wilson, Martin, rather, is there something you know about Mr. Barron? I would imagine not too much. She's gone?
She's gone.
That's okay. That's okay. Ms. Maribel, that's all I have.
Thank you. Now we'll hear from supporters. So we'll hear from your mother-in-law, Ms. Antoinette Thibodeau. Ms. Thibodeau, can you hear us?
Hello.
Hello, Ms. Thibodeau. How are you? Would you please introduce yourself and tell us what you'd like us to know about Mr. Barron?
I'm Antoinette Thibodeau. I'm his mother-in-law. I've adopted him. He's my son, and I love him to death. I take care of his babies, and they talk about him coming home and cry. I just think he needs to come home. We all need him.
Thank you very much, Ms. Thibodeau. We appreciate your comments. Is Mr. Maris there with you, or is he You are Mr. Eric Maris.
Yes, sir.
Mr. Maris, if you would please introduce yourself and tell us what you'd like us to know about your stepdad.
Yes, sir. My name is Eric Maris. He's just loving and caring, and every time I've been around, like for barbecues and stuff, always grateful to his kids. I mean, he's amazing to me. I mean, he treats me like one of his. Play football. I mean, I've learned a lot from him to grow up, be a man, go through life and all that. But he's amazing.
Thank you very much. Appreciate your comments, Mr. Maris.
Yes, sir. Thank
Mr.
you.
Barron, is there anything you'd like to say before the panel votes?
Just that I've learned my mistake and I need to go home and take care of my babies.
Mr. Barron, is the panel ready to vote? Ms. Jackson?
Mr. Barron, sometimes we make life so hard for someone as a sex offense that it's almost difficult for them to succeed. Really. But then on the other hand, there's a reason. Not every offender does as well as you had done on parole. So they err on the side of the worst of the worst. But I understand that it does make it very difficult for a person to make it in the world with all the restrictions that are placed on you. And one of them was that you couldn't be on school or within a certain distance of school. But I understand as a dad how you wanted to see that young man play football. You were there with your family. You weren't there for any, purposes of, looking for children to abuse. But the fact remains is you can't go, can't do it, can't do it. But when I looked at your overall supervision history, it was really good. It was an excellent supervision. We only hope that all of the offenders, complied the way that you did. So my vote today is to grant your parole. I think that you demonstrated that you do comply with the rules when given the opportunity. You admitted that it was a lapse in judgment. But on the other hand, I can understand your desire to see your stepson play football. But my vote today would be to grant your early release. I'm just one vote.
Thank you, Ms. Jackson. Ms. Wise?
Mr. Barron, I concur with my colleague. My vote is to grant as well. You had a good transition plan and good family support. And what I would like for you to do this time is when you get your sex offender contract, give family members a copy of it. They are on your team. They want to help you stay straight. And so everybody will be on the same page about what you can and cannot do. Because sometimes it's hard when they even ask you, because it's not top of mind. So my best wishes to you, sir.
Thank you. Thank you, Wise. You have 2 votes to grant. My vote would likewise be to grant same conditions as outlined. Good luck to you.
Thank you, sir.
Before I jump in, some of you might have seen these hearings already. It's because I did them when I first started the channel over a year ago, and Richard and I thought it would be a good idea to go over these hearings again and to share any updates, what has happened, and also any research that we now have. This specific hearing, we don't have any research or updates. I might say that the lack of an update could be a good thing, that they made the right decision in this case. We don't have documents on how horrible his crime was, but it must have been bad if Ms. Jackson was saying that. It's interesting in this kind of case where he has been let out, hasn't gone back into trouble, and where he went to a football game to watch his stepson play football, and that an officer there, a police officer recognized him and reported him. That's pretty amazing. I mean, it must be a really small town, or, yeah, you know, and you might say, wow, should he have, like, in this situation, should it have been that strict? But I remember posting this video last time and reading comments from people because I had thought that it was being overly strict, and others were like, no, he's an offender, and people, he can't go. And the idea that he's going and looking to break the law is a problem. And his family shouldn't have been encouraging him to do that. Must have been embarrassing, though. I wonder if he got arrested at the scene or if it was something that happened later on. But imagine what that would have had on the impact of his stepson if he had gotten arrested at the game. I don't know. What do you think? Do you think that it's over? That's yeah. You can't get. But he's been out of trouble even until now, a year later, and hopefully he stays out of trouble. But we'll keep moving on with other hearings, and let me know what you think. These uploads have very few views relative to others, so most of you probably watching this would not have seen it before. But yeah, with that, we'll move forward.